Welcome to The Tune, the urban narrative experience, where we bridge the gap between community and grassroots organizations that promote peace, environmental, social, and economic justice.
Welcome, everyone. What a great opportunity to be with you again here on The Tune, the urban narrative expression. Things that you want to know, things you have to know, and things that we want to tell you. We're very thankful today to have with us none other than the esteemed Dr. Earl Murray. We're very thankful to have him with us today as we are going to be talking about justice. Folks say justice, no, just us. We're talking about justice for you, by you, but understanding what your responsibilities are. Dr. Murray, would you introduce yourself and tell the folks who you are?
Yes, I will, and thank you for that introduction.
Yes.
To my left is Bishop Robert Lyon, and directly in front of me is Attorney Andrew Miley. Andrew Miley is a defense attorney, well established in Northwest Ohio, outside of Northwest Ohio, regionally and nationally as an excellent, outstanding defense attorney.
Wonderful.
Andy, we appreciate your being here today, and we look for the opportunity of talking with you about some of the things that are occurring in our city.
Dr. Murray and Bishop, I'm honored to be here with you today, and I hope to, share some useful information about the law and how that law works in the real world with your viewers today.
Thank you. One of the things we want to do is try and educate and teach. Teach
Yes.
what a legal self-defense means based upon the law that was passed, where you are able to carry a firearm, concealed weapon, and you do not have to retreat, but it's commonly known as stand your ground, which is just a term used, stand your ground, but that is not actually the law itself. So I would like for you to talk about what that law is and how it applies to stand your ground commonly used.
Absolutely. So there's a few things in your question, Dr. Murray. There's the idea of self-defense, how that works, how the use of deadly force works in self-defense with a firearm, and a new law in Ohio that passed last year where you no longer need a concealed carry permit, except you need a concealed carry permit if you're in a school zone. You do need one for that situation. So there's three laws that really interact here. And first of all, in Ohio, it had traditionally been that you needed a concealed carry permit to have a firearm to carry concealed. Ohio got rid of that requirement in 2022, and now you can have permitless carry, open carry. As I mentioned earlier, there's an exception if you're in a school area. And of course, you can't carry a firearm if you're disqualified, if you have a domestic violence conviction, a federal conviction, or if you're out on a bail restriction or something like that. So I want to talk about people who otherwise can legally carry, okay? Mm-hmm. So it used to be Ohio had what's called the Castle Doctrine, and that was if you were in your home and also your vehicle in Ohio and you needed to use self-defense, you had no duty to retreat from either your home or your vehicle, whether that be regular self-defense. Not all self-defense has to involve a firearm. It can involve, fight a knife. It could involve your fists, any type of self-defense. But here we want to mostly talk about firearms today. So if someone attacked you in your car or your home, you had no duty to retreat. However, if you were confronted in any other situation, generally speaking, you had a duty to try to get yourself out of the situation and retreat before using self-defense, especially lethal or deadly force, okay, with a firearm. Ohio lawmakers in 2021 changed that, and now if you're in your home, your vehicle, or any place that you are lawfully allowed to be, you no longer have to retreat, okay? Mm-hmm. However, And that makes a little bit of sense, because if someone is attacking you, and you're in a lawful place, why should you have to retreat from that person who has no right to attack your person or your family in the first place? But a common misperception is, and I think it's maybe urban myth or folklore or how the media has portrayed it, that just because there's a stand your ground law, if someone invades your personal space or offends you, you can just shoot them on the spot. No, that's not what this law is about. First of all, in any self-defense situation, you can't be the one who started the altercation, okay? So you don't get to pick a fight, for example, and then have the other person defend themselves and then pull out a gun and say, well, I was just defending myself. No, you started a situation, so you're probably not going to have a viable self-defense claim. So you can't be the party at fault in starting the altercation, A. B, your defensive force has to be proportional to the danger at hand, okay? So a 16-year-old boy slaps you with an open hand, okay? Can I stand my ground and shoot this person? Probably not. That is excessive force. That's not reasonable for the threat. So there has to be, A, you can't be guilty of creating the situation. B, it has to be reasonable in relation to the danger that you're facing. And so what the courts have said is there's an objective and a subjective test. Subjective meaning you actually have to believe that you're at risk, okay? Mm-hmm. And it's objective in the sense that belief, a normal person would say that that's a reasonable belief. You can't just say, well, I was scared, therefore I'm justified. Your fear and your use of force has to be reasonable under the circumstances, okay? So if those elements are met, you didn't create the situation, someone invaded your space and threatened you, and if there's a danger, an objectively reasonable danger to your life or the life of another, only in those circumstances may you use deadly force without retreating. It's not, he talked to me, he disrespected me, I'm going to stand my ground and shoot this person or stab this person. That's not what Ohio law is, okay? And, I think we're going to get into some more subjects, but I just want to give that's the general overview. And there was a recent change in Ohio law where it used to be you had the burden of self-defense. There's a change that's somewhat friendly to the defendant. The state now, if there's any evidence that it's a self-defense situation, the prosecution, the state of Ohio, here in Lucas County, the Lucas County Prosecutor's Office, would have to negate a claim of self-defense rather than the defendant having the burden of themselves proving self-defense. But regardless of whose burden it is, these issues of who created the situation, was it proportional and reasonable under the circumstances, are always going to be thrown into the mix. So yes, the stand your ground law, I don't really like to call it that. It's actually a statute, and I brought it. It's in their Ohio Revised Code, section 2901.09, and it says basically a person has no duty to retreat before using force in self-defense, defense of another, or defense of that person's residence or their house, if that person is in a place in which the person lawfully has a right to be. So if you're somewhere where you lawfully have a right to be, and you're going to use self-defense, you don't have to retreat first. So that's another important situation. If you're somewhere where you have no right to be, okay, you don't get the benefit of this new law. You have to have a right to be there. You had to not create this bad situation, and your use of force has to be reasonable and proportional. And so nowhere in the statute does it use the word stand your ground. Right. That's just a media phrase that's been put about. And so if you're going to use force, especially lethal force, you better make absolutely certain that it's justified under this statute. And you better make certain that the firearm that you have a right to be carrying that firearm.
I was going to
in the
ask
first
that,
place.
Yeah.
Attorney. Many times, folks have the weapons, but they may not be registered to that individual. So I'm glad that you talked about that needing to be one of the facts.
With a right to carry a firearm comes great responsibilities under state and federal law. So I can't speak to every single person's unique situation, but if you're going to carry a firearm for whatever reason, for defense or just to feel safe, you better make sure that you dot your I's and cross your T's, because if you get in a bad situation, no matter whose burden of proof it is, you're going to be the one stuck in that situation and regretting, I wish I had thought about this earlier.
And should that firearm be registered?
I would say there's complicated registration laws.
Right.
Ohio doesn't have a registration law.
Under certain circumstances, I believe they do have to be registered, depending on the type of weapon and where it was purchased. Where you purchase it, the ATF is told if you purchase at a firearms dealers are required to notify the ATF of the purchaser's address, and the date of purchase and the serial number. Right. And the ATF, if a firearms dealer, I had a situation once where I represented a firearms dealer and they had forgot to do that in a particular sale, and we had to self-report to the ATF on that issue. Now we got it resolved, but their license, their dealership license was at risk. So whether you think the government knows you have a particular firearm or not, there's all manner of ways in which the government tracks these things, okay? And you just got to make sure you're within the bounds of the law.
So, Counselor, can we, for the person who doesn't have a doctor of jurisprudence,
Sure.
and they are operating under the auspices that they found a handgun in the alley and it would just happen to be loaded, and they really didn't know where it come from or what kind of weapon it was, and they find themselves in a situation where someone is shot, they allegedly shot the person, and is there a legal criminal defense that you could operate under, that it was, you would advise the client that it was self-defense because they had the right to carry the concealed weapon and it doesn't matter what the circumstances were?
So in that situation, there's a fatality situation.
Yes.
And someone is a suspect in this fatality.
Yes.
Bishop. And so then the question is, so in this situation, the person, the client, my client, or the defendant, or the suspect is claiming that they needed to defend themselves and they happened to find a firearm. Is that what you're saying?
He found it. He's 4'8", and the other guy's 6'4", 350 pounds.
There's a defense in the law called, assuming that that's what happened, assuming that to be the case, there's something related to self-defense called the defense of necessity. And if you're in a situation where you're attacked by a much bigger person and you need to use force and it's justified, and you happen to find a loaded firearm there, then I think you probably would be justified in that situation. However, if that's what the defendant's story is going to be, I think the prosecutors and the police are going to be highly suspicious of, there was just a firearm that was happened to be found at that situation, and they may think that you actually created, or lying about that, and you created the situation and are now trying to, I don't want to say hide, but leverage the self-defense claim under false pretenses. And that's what I really want to impress upon. That leads me to a point I really wanted to make today, is we can sit here on a podcast or up at University of Toledo Law School classrooms or in our ivory towers and talk about the finer points of self-defense law. But at the end of the day, if you are in a position where you have to raise the legal defense of self-defense, especially in a firearm case, either a felonious assault or a homicide type case, that means you already have the title of defendant, okay, in front of your name. And that's what I want people to avoid in the first place. I would much rather educate people on what the law is up front to try to avoid these situations, rather than have the people come in my office after a tragedy struck, even if they're completely innocent and it's a legitimate self-defense, and have to hire me and get out of the situation. But if you're in the situation where you're charged with a crime and self-defense is at issue, neither Dr. Murray nor the bishop are going to sit here and rule upon that claim. The law professors aren't going to rule on that claim. The judge may not even be the one that rules on that claim. It will be a jury, okay? A jury. And we know that of the phrase jury of your peers, but you don't always get a jury of your peers, okay? And we talk about jury selection. Well, jury selection is itself a bit of a misnomer, because really what you get of a jury is the people left over who didn't get kicked off,
Right.
okay? It's kind of like the kickball team nobody wanted, okay? So yes, we have a jury trial system, and I believe that is the best system in the world, and I believe in that system. But you don't want to put your fate in the hands of 12 people who you don't know. You would not ask 12 people on the street corner after a Mud Hens game, who should I marry, or what job should I take, or what stock should I invest in, or should I get a divorce, or should I raise children? Should I have children with this woman or man? Okay, but you wouldn't go ask 12 people at a concert, at one of the concerts downtown, to make these huge decisions. But if you're going to carry a firearm and you're going to be quick to use it, you're putting your fate in the hands of 12 people. And so the law, the stand your ground law, as I said, I don't really like to use that phrase, but we'll use that, 2901.09, does not differentiate between religion, gender, or race, okay? But what I've found in my own experience, and I did some research, academic research before coming down here today, is how this plays out in the actual real world that we live in. So the numbers are sad, okay? So when the shooter and the victim are both white, 11%, and these are fatality cases, 11% of the cases have been deemed justifiable self-defense. So, okay, when they're both white, 11% justified. That means 89% not justified. So your odds are really already bad when it's a white shooter and a white victim. When both parties are black, the success rate of the defense falls 3 points to 8%. So a black shooter, black victim, 8% success rate in raising self-defense. But now when we start playing with this a little bit and change, a mixed race situation,
Right.
when the shooter is white and the victim is black, the success of the self-defense jumps to 34%, which is sad. So a 300% increase of white on white. But if we reverse that situation and the shooter is black and the victim is white and a claim of justifiable self-defense is raised at a jury trial in America,
Right.
3%. 3%. 97%
Is against.
is against if a African American uses lethal force on a white alleged victim and goes to a jury trial in America and asserts self-defense, it only works 3% of the time. So that's why I was saying the law is written neutrally and equally. And I do believe that was the intent of the legislators. They wanted everybody, regardless of who you are, to be able to lawfully defend yourself or your family if you need to. But how that plays out in the real world is not equal.
Can we touch a little bit on the real world? How we have social disadvantaged individuals. Attorney, you talked a little bit about what we already should know prior to becoming the defendant. Yet that level of education doesn't generally exist until you're in this position of
Yes.
defendant.
Yes.
And in this real world, even as we know, here it is, you can own a firearm at 18 actually. Am I correct?
Yes.
And you can go and purchase this firearm and be out in the community with this firearm with little to no education. Yet once you become that defendant, you have that 3% chance of being told, yes, you were right for defending yourself, but 97% that no, you were not, if the victim is white. And then it's even worse if it's only 8%, 5% more if the victim is black. Can you talk a little bit about that disparity? Because that's exactly what it is.
It is a huge disparity, and it's one more reflection of the inequity in our society. I wish I had a really good answer for that. I would probably be, I don't know what I would be, probably maybe president of the United States or something. I think, though, that program, this is why when Dr. Murray asked me to come on today, I jumped at the chance because, yes,
Wonderful.
you want to use education. So even though Ohio doesn't have the concealed carry law, even though you don't need a concealed carry permit anymore except for outside of school zone, the classes still exist, okay? So I think, and you still can get your concealed carry permit if you complete the classes and are otherwise eligible and approved. So I think taking those classes that really focus on gun safety, and even though the law anymore doesn't necessarily require, as a matter of law, a duty to retreat, but they teach you in those classes maybe you should retreat still, okay, because of this 3% or other statistics. And once you fire that gun, you can't put the toothpaste back in the tube, okay? So I think those classes try to teach you, yes, firearm safety, but also common sense. How do I, if I'm going to carry, how do I not put myself in these in situations? And sometimes, obviously, if it's true self-defense, you didn't put yourself in the situation. So the aggressor did, or the perpetrator did, and there's nothing you could have done about that except react the way you did. But I think that in our culture, movies, etc., sort of glorify, I'm the man, I'm invincible, I'm 7 foot tall and bulletproof, okay? I can't be touched. But once you do that, and if you become convicted, I've seen it before, in the sense of regret of the convicted person and their families is something I will never forget. If I could just take that back, or if I didn't go there that night, or if I had just left, okay? If I didn't provoke the situation in the first place. A lot of times I see these situations when there's alcohol involved. It's already illegal in Ohio to possess a firearm when you're under the influence of drugs or alcohol. So I think that's a big part of it. Making sure that you're not using drugs or alcohol when you're carrying a firearm, because those substances, by definition, impair your judgment. So I think there needs to be a lot of conversations like this, and a lot of training. Like I mentioned earlier, we have a lot of freedoms and a lot of rights in America, but with those comes a lot of civic responsibility, I believe. And you don't want to get your civics lesson during the middle of your jury trial, okay, or in your appeal. You want to try to think about these issues up front.
As we look around the panel, those of us that are here, and also look at your legal perspective from being a criminal defense counsel, how do you think we could best attack the increase in broader education toward those persons that are the most likely to either be incarcerated for using a weapon that did kill someone, yet as we fight first to try to identify who has the burden of proof to prove that it was self-defense, maybe if we could broaden the education platform for those persons that are in the African American communities and other communities where guns are just prevalent and as normal as a pen in your pocket to write a note. What could we do to possibly affect that from the legal community minds, the courts, the communities themselves?
That's a tremendously great and complicated question, Bishop. I don't want to sit here and pretend to speak for the African American experience in Toledo or any other community in the United States, but I have been involved in, I've been around the block more than once, okay? And what I've seen in a lot of these types of cases is exactly what you said. The people who, I think you said, guns can be as prevalent as a pen in someone's pocket. And that, it's literally an arms race in our neighborhoods and in our cities, because when you come to that realization, you are a little more, if everyone around me is packing heat and I'm not, I'm at a disadvantage. Exactly. And of course, with that comes stress. Mm-hmm. So now I'm on edge. And there's other stressors in life: jobs, family, all these stressors. So, how do we deal with this situation? First and foremost, I think we just try to get back to basics a little bit in terms of what we can teach about the law. Is what I started out with is you cannot create the situation. So we educate people. You cannot create the situation. If you create the situation, self-defense is probably not going to be there to save you. Okay?
Okay.
If you do create the situation, self-defense might be to save the other guy, okay, who defends himself or herself against you. So just let's try to take a breath and not create bad circumstances in the very first place.
Let me
Yeah,
ask.
but that, I'm
Go
sorry.
ahead, Doc.
But that's also crafted on the fact that, excuse me, you also have to take into consideration who it is that you're being confronted against.
Yes,
And racially speaking.
yes,
And the evidence is already documented that a black who goes against a white, even in self-defense, the error is that 3% is not favorable.
it's not favorable.
And that means that the jury in those cases have made a decision who perhaps do not look like you, that you didn't have the right to do what you did. So you also have to think about that while you're also doing whatever you think you want to do.
Right, but
Which goes to Bishop's question about educating folks.
educating folks.
And my recollection is in getting a gun permit is that though they do not talk about education insofar as the law goes, but only to the extent how to use a firearm.
Sure.
So communities need someone like you to hold workshops or seminars or something to educate people beyond just carrying a gun.
Well, that's was going to be my next point. No apology needed. And I, whether it's me or other attorneys or even the prosecutor's office, perhaps to educate people, is the other element of it is it has to be proportional. It can't be you spit on me or you talk bad about my girl or my man. Okay, there has to be a sense of proportionality involved, and I think with all these stressors, we were, Bishop mentioned about, we know people are carrying. It might be in a disadvantaged community to begin with, so there's extra level of stress. And if you're going to carry the firearm, you got to constantly be mindful of the fact that I am not on a movie, okay? This is not a video game. My response has to be proportional. And if it's not proportional, I'm probably going to be in some very big trouble, because the first person that is going to look at self-defense is going to be a police officer or a detective. And they're going to make a determination way at the start, do I think self-defense was here or not? And then they'll write a report to the county prosecutor's office, okay? And some assistant county prosecutor, who might only be a year or two out of law school, okay, and not very experienced, is going to write a report to whoever, either the head county prosecutor or to the person at the prosecutor's office who's in charge of grand jury indictments. Then the grand jury is going to decide whether they think this was justifiable self-defense or not. And they can issue an indictment. And to get indicted, they say you can indict a ham sandwich, okay? At a grand jury, the suspect has no right to be there. The suspect has no right to have counsel there. It's a totally secret proceeding, and it's just a probable cause standard, okay? So at the grand jury level, self-defense is probably not even really in the picture, okay? And then it goes to the judge and then to the jury. And I know there's another question coming, but I want to make another point. If you're in the realm of self-defense, this is what a lot of people don't realize. Basically, if your defense at trial is self-defense, basically you're admitting, yeah, I committed the crime. I did this, but I'm excused because of the self-defense law. So if you're asserting self-defense, that's a defense that basically leaves no room for error, because to claim self-defense, you got to admit that I'm the one who did it, okay? And yeah, this person was hurt or died because of the gun that I fired, but I was justified. Think about it. In the real world, you can't say to a jury, I'm not the guy who did it or the woman who did it, but if I was the guy, it was self-defense. I mean, that's not going to be a very compelling defense. You got to pick one or the other. It wasn't me, okay, or it was defense, okay? And one more point, Bishop, you asked about the burden. It used to be the burden was 100% on the defendant. So usually the state has the burden of beyond a reasonable doubt on the elements. All crime is made up of different elements or building blocks. And for the state of Ohio to get a conviction, generally they got to prove every element beyond a reasonable doubt. If any element is missing, it's like a game of Jenga, the case falls apart, okay? But if the state proved its case beyond a reasonable doubt, the defendant would get a chance to, during the trial, assert self-defense, and they would have to prove self-defense by a preponderance of the evidence, or 51%, okay? Now, the change in the law is the state has to negate self-defense. The Supreme Court of Ohio recently had a decision that came out last year that said, while the state has to negate self-defense beyond a reasonable doubt, so now state has to negate self-defense beyond a reasonable doubt, they're still, in order to require the state to negate self-defense beyond a reasonable doubt, there has to be some evidence, testimony, video, some kind of evidence, physical evidence that suggests potential self-defense. And then if that evidence is out there, then yes, the burden is now by law shifted to the state to negate that claim of self-defense, or to negate that evidence beyond a reasonable doubt to show that it was, to prove a negative, that it was not self-defense. However, in the real world, however fancy we want to define the burden of proof and preponderance and all that, I think the numbers kind of bear it out. It almost doesn't matter as a practical speaking whose burden it is. A jury is going to, there's a famous Supreme Court case where it was about pornography, and Justice Felix Frankfurter said it's hard to define, but you know it when you see it, okay? And I think that's in a lot of what I've learned. When I was a younger lawyer, I would focus a lot on they need to prove this, and then they need to prove this element. But what I've kind of learned is that the jurors, I think, make up their mind pretty early on in a trial, and then they filter the evidence as through their predetermined result that they've kind of made their mind up already, okay? And so they kind of know it when they see it. You kind of know self-defense when you see it. And I think there was a question coming over here.
Go ahead.
Yeah, I just want us, in wrapping up our discussion, the reason why it's so important is because you have a jury of your peers generally doesn't mean a jury of your minority peers. It generally means the dominant culture or the majority is sitting in that room. You don't generally, who gets to select those peers?
Sure.
One, right? Then the interpretation of 2901 .-09,
Sure.
that revised code, who interprets that?
That's a great question. So let's start on the second part first. Who
Okay.
interprets that? So at any jury trial, at the end of the case, the judge will give the jurors instructions on what the law is. And the jurors at the beginning of the trial and at the end of the trial give an oath and a promise that they will follow the law. They will follow the instructions given to them by the judge. They're not supposed to substitute their own version of the law for what the law is. So the judge interprets the laws, and then that comes to the jury in the form of instructions. Now, the judge reads the instructions, self-defense to the duty to retreat or not, which Ohio there is no more duty to retreat. So the judge would instruct the jury on 2901.09B, and the jury is supposed to apply that. And those instructions come in the form of orally. The judge will read the instructions. But we all know, if there's 15 pages of instructions, kind of hard to follow along. And then, but also for that reason, most judges will allow the jury to have a written copy of the instructions in the jury box room. And oftentimes, juries will come back during their deliberations with questions about, can you clarify this or clarify that? And sometimes the judges will do it, issue a clarification, but oftentimes they'll say, well, what I told you is what the law is, and you got to do your best with the instruction. Now, how do we pick a jury? So in many counties, a jury pool is made up of voters or registered driver. People have driver's licenses, okay? And the county clerk of court will have what's called a jury veneer, or a long list of people and potential jurors. And usually if it's a homicide trial, they may call in something like 80 jurors or something like that. And the attorneys on both sides will get the jurors' names and addresses maybe a week or two before trial. And usually they will answer a small questionnaire about themselves, okay? You can kind of get where they live, their age, where they work, who their doctor is, who their lawyer is, do they have any special medical issues that would prevent them maybe from being on a jury trial, and you get who their children are, who their spouse is, if any, and you get maybe a little teeny snapshot into who these people are. And so then the lawyer, as a defense lawyer, you're looking for, okay, who do I want on this jury? So then what happens is there's maybe 80 people in the courtroom, and the judge randomly calls up 12, okay, into the jury box, or maybe 13, maybe you have an alternate. But for felony trials, there's 12 in Ohio. And the state asks questions first, try to figure out if these people can be fair. Are they biased? Are they prejudiced? Let the jurors know how long the trial might last to see if there's any special problems where they won't be able to stick around that long. Because you don't want juries who rush to make a decision. And then the defense lawyer gets the same chance, okay? And each side gets 3 or 4 what are called peremptory challenges. And either side can kick off any juror off that pool for any reason, basically except race, okay? And I'm going to get back to that in a second. And each side has unlimited challenges for cause, meaning there's good cause to remove this person. They wouldn't be fair, okay? Maybe they themselves know the detective involved or know the defendant involved. They probably could get challenged for cause. And then after everyone uses their peremptory challenges and there's no more challenges for cause, you have your kickball team, your jury, your leftovers. And a lot of times it's people that are retired or people who are unemployed, okay? Because a lot of people are trying to get out because of their jobs. I understand that. I think the jury trial is what keeps America. It's very important. So I think it's a civic duty, as important or more important possibly than voting. And that's another thing I think African community could focus on is let's make sure we sit on jurors and let's not on juries, okay? In minority communities, that could be let's make sure we're registered to vote, because not only we get to vote, we're on the jury list. Let's make sure we have our driver's license. Not only can we drive legal, we're going to be on the jury list, so we can get a more diverse jury of the peers. Now back to peremptory challenge for race. Say Earl is on my jury, and I want him because I think he's fair. And let's pretend I didn't know him, but I'm a lawyer, and this guy seems like a fair man. And my client, say, is the bishop. And so we have an African American juror. He seems like a fair and educated man. And the state of Ohio says, Your Honor, we would like to strike Dr. Murray, use a peremptory challenge, one of our 4 peremptory challenges, and we thank Dr. Murray for coming here today, but we'll strike him. And it's like, well, why would they do that? There's no challenge for cause. So if you remove an African American juror, particularly when the defendant is African American,
Bring it home. All right. I
There,
hear you.
there's a problem there, and the trial court can say no. And there was a trial a year or two ago like that in Lucas County where an African juror was removed, not for cause, but for a peremptory challenge. And the man was convicted with no African American jurors, and the Court of Appeals reversed that. Thankfully, reversed that decision and said no. That this was basically a racially motivated removal of this juror, and that violates the Ohio and United States Constitution. So yes, there's no guarantee you're going to have if you're an African American defendant, you're going to have other African American jurors. If you're an Asian defendant, there's no guarantee there'll be other Asian jurors. It's almost impossible to guarantee that, but when those people do get selected and are on there, the state better have a very good reason for trying to pull them off the jury. And they have to give
to the judge.
but it's significantly up to the judge. They're supposed to give a race neutral reason as to why, and it is up to the judge. And in that case I mentioned, the judge, there was a challenge and the defendant objected. The judge denied the challenge that the defendant made. The defendant was convicted, but there is a Court of Appeals, and that was reversed. But nobody wants to be, so that man's rights were protected, but he had to go through a trial, get convicted, go to prison, do an appeal. I want to see
Which is also very
avoid
costly.
extremely costly,
I was gonna say,
tens of thousands of
yeah.
dollars or more.
Yes.
And so there is a system of checks and balances in place, but the system depends upon the integrity and the fairness of the people involved. And that's why we need people of goodwill of all different backgrounds to see, hey, I need to become involved civically, okay? I can't complain and expect change if I'm not doing, if I'm not willing to sit 2 days on a jury trial.
There you have it.
I can't help you.
There you have it. The whole process of disproportionality starts and ends in education. We have to make sure that our children, our families are educated in regards to stand your ground is what we call it in our regular language. In the legal language, 2901.09, Ohio Revised Law Code, you have to understand what it is. And at what level do we begin to educate our families? Is it in kindergarten all the way up to high school? Well, when they change and they get out into the world at 18 years old, they can own a firearm. I would think we would start educating in TPS, in our high schools, in our parochial schools, that there's a responsibility when you own a firearm. You heard it not from just folks that operate the tomb, but folks who have been taking an oath to provide criminal defense for our loved ones. Please, 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 when you listen to this podcast, make sure if you have questions that you can leave it in the reviews below on the YouTube, and that you can continue to listen to The Tune, the urban narrative expression. We're not done yet. There will be justice, and it will be for everyone. Thank you. Looking forward to our next session. Have a good one now. We gotta have a little bit more conversation. We got Gutta Dave with us, and the people on the block want to know when do I start telling or talking about what has happened. And so, Attorney, if you could, and Dr. Murray and Bishop, when should our young people, our elders, our folks that are supposed to be in this space of defense begin to talk about it?
I'm going to yield to Attorney Miley and let him talk about the fact that we need to learn when to talk and when not to talk when you're faced with a criminal defense situation and you need counsel.
So, anytime you're in a situation where police are questioning you, you have a constitutional right to remain silent. Everyone talks about their First Amendment right to speech. You have a right to not speech. You have a right to silence. Okay? Exercise. Everyone wants to exercise their First Amendment right. Exercise your Second Amendment right to bear arms. Exercise your Fifth Amendment right to remain silent. And the United States Supreme Court has said, in a case that came out of Ohio, that the Fifth Amendment right to remain silent, yes, it can sometimes protect people who are guilty, but it protects people who are innocent too.
Yes.
It protects all people, white, black, doesn't matter, men, women, young, old. You have a right to remain silent. And I say, anytime a police officer or a social worker or a government employee, some type of investigator is questioning you about something, you say, I want to invoke my right to remain silent, and I want counsel present. Sixth Amendment right. Same thing, Sixth Amendment right to
give it to
counsel.
us.
I want to remain silent, and I want my lawyer or my legal or my attorney present. There's the Fourth Amendment, too, that police have to have a search warrant issued by a judge based upon probable cause to search. So if police come to your home and say, can I look in your trunk, or can I look in your house, or you're on the side of the road, and they really don't have any basis, or even if they do, can I have your consent?
No.
Earl, do you know what the answer is?
No.
No. You do not have my consent, and I want my lawyer here. Bishop, that's what you tell people. Because here's what happens to innocent people, particularly. They're extremely nervous, okay? And they there's no gun in their car, okay? But they give consent, and then there's maybe a little marijuana in the car or something. Mm-hmm. And then one thing leads to another. Or they talk, and they say, I wasn't, and they give details about where they account for where they were that day, and they forget. Earl, if I asked you last Thursday, where were you? You probably, you might remember, but Bishop would remember, but I don't know that you or I would.
Remember.
Okay. Yeah. Where were you? What were you wearing? So people might give details about where they were or what they were wearing, and then they misremember, and then they come back later and try to clarify, or the police get surveillance tape and you were not wearing a red hoodie but an orange one, and they're saying, well, this person must be guilty because they're changing their story or they're omitting their details. They could be totally innocent, but if the detectives are convinced that you're the person they want to nail, they're gonna, just like a jury filters evidence, okay? Yes. It's just human nature, okay? They're gonna filter the evidence, and this person gave me details that aren't totally consistent, or they omitted this thing, okay? There might be something embarrassing. Maybe you were cheating on your spouse, okay, and you're embarrassed, okay, or you're doing something you shouldn't have been doing, but not committing a crime, okay, but so you make up something because you're nervous. There's a very simple and extremely easy way to avoid that, which is the Fifth Amendment right to remain silent, the Fourth Amendment right to say no to give consent to searches, and a Sixth Amendment right to counsel. Those are beautiful rights. There's nothing wrong with exercising them, and that's the United States Constitution. The Ohio Constitution, a lot of people don't understand that Ohio has its own constitution, and it has similar rights, and the Ohio Supreme Court has said that the right to remain silent, etc., is more strong under the Ohio Constitution than it is under the United States Constitution. The United States Constitution just gives you bare minimum rights. States are allowed to give more civil rights and liberties through state constitutions, and the Ohio Constitution has. So if you say, I want to talk to a lawyer, you can't consent, or no, I want to talk to a lawyer, or you can't search, I don't consent, or I want to remain silent, they're not allowed to use that against you to a jury, to a grand jury. It cannot. You have a God-given inalienable right to not subject yourself to this, and this is where people get in trouble. They speak to people without counsel, and the police often depend upon that pressure to cooperate and then exploit it. You cannot lie to the police. The United States Supreme Court has said over and over, the police can lie to you. Okay, they're allowed to engage in trickery and deception. okay, to get you to talk and to get you to say things that when you have your wits about you otherwise normally never would. So yes, whether it's a case involving a firearm, a fight, or a self-defense case, or any type of case, okay, any type of investigation. I went to law school at Notre Dame for 3 years after 4 years of undergrad. I've been practicing law for 20 years, and I myself would never talk to police during an investigation without hiring. I wouldn't counsel, okay? A lawyer who represents himself as a fool for a client, okay? Right. If the average person who doesn't have legal training tries to talk to the police without help, I mean, that's like trying to get through cancer without seeing a cancer doctor. It just doesn't make, it's not rational. Lawyers are here to help.
And then that's a good point you made, and Alicia made, and people should remember. And it's easy to remember, and Will Rogers said it best. Never pass up the opportunity to keep your mouth shut.
Yep. And
you do not have to talk because someone asked you to talk.
And my friend Monty Montgomery says, if you don't know what you're talking about, how the hell do you know when to shut up? Right. And so and if you cannot afford a lawyer, it doesn't matter, right? Because the American legal system, and this is a point of pride for me, is we've seen it as a taxpayer obligation to help people who we're not going to let the arm of the government, state or federal, go after people and without providing the suspect or the person under questioning a basic legal right to counsel. The United States Supreme Court has said that the right to counsel is fundamental to orderly democracy and liberty. Okay, so you can ask for counsel, and they have to give it to you.
Wait, but let's talk about that. Go ahead, Don. Go ahead. What were you
I'm
going to say?
glad that Andy brought that up because one of the things that I pride myself off with Attorney Malley is I have called him numerous times. That means more than once, twice, numerous times, to take cases for individuals who were indigent, who were stressed, legal defense cases.
Correct.
And he has never once refused, And we have individuals in our community, many of whom do not know what their rights are, some of whom cannot even afford to go and get counsel, and they need to know that they can't just go and get counsel for free, pro bono publico, but they do need counsel, and they don't know who to go to. And we need a network where we make sure that we educate folks on where and who to call when you need counsel.
That's it. That's the bottom line. Where do you go? And many times you have the good, bad word of counsel will be provided for you if it's a public defender.
Yeah.
And then if that public defender doesn't do due diligence in some spaces, folks don't know what to do next. So folks, we got a lot to talk about.
Public defenders know one thing, and I'm not speaking on behalf of Attorney Malley, but I know this for a fact. They have one outcome: plead you out.
And that's
plead you out means you admit there's no work involved, you lose, so you taking a plea and you are found guilty. So that no contest stuff never means that you're going to be found innocent.
Yeah. So
no, never take a no contest.
Can I make a couple points about that?
Absolutely.
Many public defenders are great lawyers, but the way the system is structured is more resources are put to the prosecution's team than the defense team.
Yes.
And they just get burdened with cases. So if it's hard to convince legislators to spend funds for legal defense, but I think that both aisles, Republican and Democrat, should support that. For example, from the conservative or Republican perspective, well, you say you're against big government. Putting someone in jail is the quintessential form of big government. So how about we help our own people and give them every benefit along the way, and then yes, if they're guilty in the end, put them in jail. But we have to have a fair process along the way. So a lot of time there's immense pressures on public defenders to plead cases, but that's not really necessarily the fault of the public defender. That's the fault of the system that doesn't put enough resources in it. And I want to tell a story. 2 years ago, how public defenders work is every county does it a little bit different. Some counties have full-time public defenders, and if you're charged, a public defender's office, if you're charged with a crime or question and say, I want a lawyer, and I can't afford one, they'll appoint you a public defender from that office from the day you're questioned all the way through, the case. Some counties have a system where private lawyers sign up to be on the list. Mm-hmm. There's no public defender's office per se, and you're appointed a private lawyer. There's two ways someone gets charged with a crime in Ohio, one of a felony. One is through a grand jury indictment. I talked a little bit about the grand jury at the common pleas court, the big courthouse.
Correct.
If there's not time, if there's a serious crime or any felony that is being under investigation, and the police don't have time or don't want it to go to the grand jury immediately, they can charge you in municipal court at first, the smaller court. And then the municipal court judge sets bail, and then there has to be what's called a preliminary hearing where the state has to put forth evidence, probable cause standard only. It's it's not a full-blown trial, but they need to produce evidence under the rules of evidence that justify holding you on the bail. And then if the municipal court judge says, yes, there's probable cause, then the case gets bound over to the grand jury and they can decide to indict. In Summit County, what was happening over in the Akron area in Northeast Ohio, they had they had a public defender's office for misdemeanors and for felonies that were filed in municipal court, okay? And then if the case was actually indicted as a felony, you would get a private lawyer assigned to you. But so what was happening is you would get the public defender's office on the front end while you're in municipal court, and then a different lawyer on the when it was actually indicted, which is a terrible system because the front end lawyer doesn't have the front end lawyer knows he or she is not going to see you through the whole case, so has little incentive to do much investigation on the front end. Where you see the TV show 48 Hours, the 48 hours, first 48 hours in any investigation is the most important. So the police are putting all their resources in on the front end, but the defendants were not getting similar resources allocated on the front end by design. They were getting very little resources, and then sit around and wait and be indicted. Then I'll finally get my real lawyer a week from now, 2 weeks now, or a month from now. I represented the two only elected African American judges in Summit County, both on the Akron Municipal Court, in a lawsuit in the Supreme Court that tried to change that. We said no. There has to be a system of what we called continuous representation. And that's actually what the American Bar Association, the ABA, holds out as the gold standard, continuous representation. And we said a person of means, a moneyed person, a wealthy person, doesn't hire a lawyer for the municipal court and then go hire a different lawyer.
Right.
They want that lawyer working on their case as much as possible, fully incentivized to see the case through. And we said we want a system for indigent people that mirrors that. We know there's always going to be some gap, okay, it's just the way it is, but we shouldn't deliberately structure a system where the indigent person is not getting fully committed representation at the front end. I'm sad to report that we lost that case, and the Ohio Supreme Court said that Summit County courts could do it that way based upon the current statute controlling how public defenders are appointed and paid in Ohio. But I've tried to work with legislators to change that, to say, no, once you're first appointed a public defender, whether it be a public defender, traditional public defender's office, the state public defender, or a private lawyer who serves as a quasi-public defender, that is going to be your lawyer from the time that lawyer first talks to you until the time of plea bargaining or a jury trial or a bench trial. Same committed counsel throughout. I think that would be a tremendous change to improve the representation for indigent defendants. So that's something that our office is working on. We try to get that through the court system. It didn't work. And so now we need to turn to the legislature. And so if there's any, I would love it if Bishop, if your organization, Dr. Murray, could help us with that, because I think that's a real way. Because a lot of times what you see in inequities are resultant from the way the system is set up. And it's not even necessarily intended to be bad or be racist or to treat poor people worse. It's just like, well, this is the way that we always did it, so we're going to keep doing it. It's like, well, wait, time out, think about it. I know this is the way you always did it, and there might not be any ill will there, but when you logically think about it, this needs change. The result is ill will.
That's right.
The ill will is the disproportionate concepts of the system.
Correct.
So we can talk all day. I want everybody to think about this. Education, interpretation, keep your mouth closed.
Yes.
Don't say nothing.